Good morning, everyone. Thank you for joining us today. Whether you're a landlord, a tenant, or a real estate investor, you'll know that the commercial property landscape is evolving rapidly. I'm going to try not to mention the S word today, sustainability, as I think the benefits of that are pretty well established now in relation to how buildings are valued, leased, and managed. Can I get the next slide, please? Instead, what we're going to focus on today is one of the key trends that we're seeing at the moment, which is retrofitting solar photovoltaic panels on existing commercial buildings. I'm Graham Imray. I'm a senior associate in the real estate team here at Brody's. And joining me today in speaking with you is Claire Dewar, who's also a senior associate in our real estate team. Claire deals primarily with landlord work, often for large institutional owners, so she's really well placed to give you the rundown on the key concerns around installing a solar project from a landlord's perspective. Also joining me are Jay McMonigal, who's a partner in our construction team, and Adam Karofsky, who is a solicitor in the construction team. Adam's got a bit of an advantage here because in a past life before he became a lawyer, he actually used to work for a company that installs solar panels. So Jane and Adam are here to give us their perspective on the more practical elements of a solar installation and how making sure that having the right construction package in place is essential for a smooth solar project. The installation of solar panels affects all parts of transactions. It's not just landlords and tenants, but there's funders, investment purchasers, sellers, and owner occupiers. And we at Brody's have got a real depth of experience on these projects. What we're seeing is a clear move towards more and more landlords and tenants exploring solar installations on their existing buildings, often with sitting tenants already in occupation, and both parties really seeing the benefits of such a setup. So what we're hoping to achieve today is to give you an overview of some of the main commercial points that need to be considered when bringing a solar project to fruition and some of the key paperwork that needs to be put in place to document the arrangement. So why are we seeing such a surge in interest at the moment? Can I get the next slide, please? Well, there's a couple of reasons. As I'm sure you'll be aware, Scotland has ambitious climate targets, and commercial property owners are under increasing pressure to decarbonise their portfolios. Solar energy, I think, is one of the most viable and effective ways to reduce carbon emissions, and it allows owners and occupiers to demonstrate a commitment to improving the green credentials of their space. Linked to this, solar installations can significantly improve a building's EPC rating. And we're finding this is probably the key driver behind the desire for a solar project. It's also important to note, whilst there are no minimum energy efficiency standards for non-domestic buildings in Scotland at the moment, we understand that the new Heat and Buildings Bill, which is shortly about to be presented to the Scottish Parliament, is going to give the Scottish ministers the power to introduce minimum standards in the future. So building owners and occupiers are just trying to get ahead of the game just now to improve the EPC ratings of the buildings as much as possible. There's also a good body of evidence that buildings with strong green credentials are more attractive to tenants and investors. They tend to lease faster, retain occupants longer, and in some cases command higher rents or sale prices. And finally, solar panels can also provide additional income stream for landlords from electricity generated and sold to tenant, but also from electricity not consumed on site, which is then sold back to the grid. So I'm now going to hand over to Claire, who's going to talk us through some of the key considerations from a landlord's perspective.
Hi, thank you, Graham. So just starting with this slide, I just wanted to mention, first of all, given the time constraints today on the landlord side, we're not going to be considering the situation where a landlord is putting solar panels onto the roof of a multi-occupancy building, so where the landlord would be maintaining the structural parts, including the roof, and where there's a service charge. So instead, we're just going to be focusing on projects at single occupancy buildings, such as industrial sheds and retail warehousing, where we're seeing quite a lot of instructions coming in. So the first thing the landlord will need to do is to assess which properties in its portfolio are suitable for solar panels, taking account of the size of the roof and also energy consumption at each property. Many landlords are appointing green consultants to assist them with this process, and at some estates, a project might only be feasible if a certain number of tenants agree to sign up to it. As with any project, the landlord will need to obtain various consents, grid consents, and planning consents, and factor in the timescales and costs for obtaining those. There's then various different options available as to who will own and have responsibility for maintenance of the solar kit. Where there's a new lease, the likelihood is that the landlord will just want to pass responsibility for maintenance of the kit over to the tenant, particularly where the tenant is entering into an FRI lease. Just in case anyone isn't aware, when we say FRI lease, we're meaning a full repairing and insuring lease where the tenant has responsibility for all parts of the building, including the roof, and is essentially just stepping into the shoes of the landlord for the purposes of maintenance and insurance and repair. So, in that scenario where maintenance responsibilities passed over, the solar kit just becomes another item which the tenant needs to maintain. The landlord will want to make sure that it includes obligations on the tenant to comply with any solar product guarantees or similar throughout the term to ensure that those guarantees remain valid and enforceable. Where you've got solar kit that's going to be retrofitted onto an existing building which has already got a sitting tenant, the tenant is unlikely to want to take on responsibility for new equipment partway through their lease. It's just most likely going to be too much hassle for them. And so in that instance, it's much more likely that the landlord will retain responsibility for maintenance of that solar kit in that retrofit scenario. So there can be additional income generated by each solar project by selling power for a landlord either to the tenant or back to the grid. In terms of how important that is to the landlord clients, we've spoken with some of our institutional clients as to the benefit that they place on that aspect. We were initially wondering, could this be a new asset class? But generally, they are considering the impact of that to be quite minimal. And their focus is generally much more upon improving the EPC ratings to ensure that the older buildings remain marketable. And it does seem to be one of the few ways that you can achieve an EPC rating of A on an older building. In terms of tax and rates, where there is an additional income stream flowing from the solar kit, the landlord will want to check if its constitutional documentation does allow them to receive that income from that source, and Brodie's tax team can help review and assist with those aspects. Solar kits can also attract additional business rates, and so that also needs to be considered and thought given as to who should have liability for those rates too. Next slide, please. So I thought it would be useful to briefly outline what happens where a landlord retains responsibility for the solar kit, so in the retrofit type scenario. And this doesn't consider battery storage or anything similar to that. So the landlord will require the tenant to consume the electricity generated by the solar kit before it consumes electricity from its grid connection. The tenant will pay the landlord a fixed price for this electricity, which will typically be cheaper than the grid price. And then any electricity generated by the solar kit that's not consumed by the tenant will then belong to the landlord, and then it can be sold back to the grid, producing another income stream for the landlord. And generally, this will be documented in a power purchase agreement, or PPA, as they're sometimes called, which would be entered into between the landlord and the tenant. Next slide, please. So in terms of the legal documentation you'd be likely to see for a landlord project, as with every project, it'll start with the heads of terms between the landlord and the tenant, often involving a specialist energy agent. There will be an overarching contract. For a retrofit scenario, there will be most likely a deed of variation of the lease, or where there's a new letting, there will be a lease with additional solar provisions incorporated. There may also be a landlord works agreement setting out the obligations to be imposed on the landlord while it carries out the initial installation works. And then for either a landlord or a tenant project, there will be an operation and maintenance contract in connection with the solar plant and equipment, power purchase agreement, and also a construction package. Next slide, please. So looking at the overarching agreement, this will set out the conditions to be satisfied before the project proceeds. Ideally, from the landlord's perspective, this would be framed as an option rather than suspensive conditions. And the reason for that is it just gives the landlord a little bit more flexibility, and it means you don't have a deadline, a long stop date incorporated into the agreement. That might not always be possible, but it's definitely preferable, particularly if a project is only viable if a landlord gets maybe half of its tenants at a particular estate signed up to proceed. So what needs to be included? So to the extent not already obtained, the contract would need to be subject to obtaining planning and grid connections. It would need to be subject to obtaining a satisfactory build contract at an acceptable cost to the landlord, just bearing in mind that there could be quite a large time gap between the exchange of contracts and actually instructing a contractor. It would also need to be subject to obtaining any technical surveys that are still outstanding. And then consideration would also need to be given to any existing roof guarantees in place, which could be impacted by the SOAR install. And the landlord should also consider within this agreement if the tax treatment of the whole project, the VAT aspects of that, capital allowances, and for larger landlords and developers, the construction industry scheme too. Next slide, please. So this slide is just giving a very brief overview of the power purchase agreement. Brodie's energy and infrastructure team are regularly drafting and negotiating these agreements, so it's just a brief review of the provisions. So in terms of price and payment, in a landlord installation, the tenant will be paying the landlord the power price for each kilowatt hour of electricity that's generated and consumed on the site. And typically that will be paid quarterly to the landlord in arrears. The power price that they're paying will generally be a capped sum to begin with, so capped at X pence per kilowatt hour for, say, the first year, and then will be subject to annual index-linked increases after that on an annual basis. There may also be an additional cap imposed just to ensure that the tenant is never paying more for its solar power than it would be paying for its general grid connection. And then there will also be maintenance obligations within the power purchase agreement too. So the agreement will generally set out the landlord's obligations to maintain and repair the solar kits, and there will be some necessary crossover with the terms of the lease documentation there too. Next slide, please. So whether you're varying an existing lease, the retrofit scenario, or you're agreeing a new lease, there are some key points which solar projects affect. The first one would be the landlord's reserved rights under the lease. So if the landlord is responsible for the solar kit, but the roof is the tenant's responsibility, the landlord will need express rights to maintain and repair that kit throughout the lease term and also to remove it when it's at the end of its life cycle. The premises definition will need to be carefully considered. So in a retrofit, the solar kit and the airspace that that kit sits within will need to be expressly excluded from the premises definition, given that the tenant will be responsible for maintaining the premises. Or where you've got a new lease, if you're passing liability over to the tenant, it should be clear that the solar kit does form part of the premises and is therefore the tenant's responsibility. Turning to review, the treatment of solar kits at review needs consideration where you have an open market rent review clause. Obviously, it's not so important if you've got an index-linked review. Where the landlord is retaining responsibility for the solar kits, then the likelihood is that the landlord will want that to be, and the tenant will want it to be disregarded at review. However, if the lease is including the solar kits, then the chances are that that should be taken into account at review. It's just important to always remember to take advice from the landlord's rent review surveyor and specialist team and to consider the review provisions on a case-by-case basis. Turning to repair, again, in the retrofit scenario, the tenant will still need to repair its roof, even if the landlord is owning the solar kit that's attached to it. So there needs to be a right for the tenant to request temporary removal of the solar kit to enable such repairs to take place. So the landlord will want to consider how often such a request can be made to the landlord by the tenant and perhaps agreeing a fixed cycle, so maybe a 3 or 5 yearly cycle for these requests to be made. And also there will need to be emergency access too. And ideally that should be agreed in advance and written into the agreement. And turning to alterations, the landlord will want to ensure that the tenant isn't permitted to remove the solar kit or to do anything which could damage it. More generally, we're all seeing green lease clauses coming into our leases more frequently. And usually in the context of alterations, they will prevent tenants from undertaking alterations which will lower a building's EPC. Where a landlord has incurred the upfront material costs of installing the panels, it won't then want the tenant to do anything to any other part of the building, which could then lower that rating. Just turning to insurance, the landlord should check what impact the solar kit will have on its insurance policy where it's insuring, and consideration should be given as to who pays any increased premia, depending on the circumstances of who has responsibility for that kit. And then dilapidations. So in the retrofit scenario, where the kit is being owned and the landlord's responsible for that kit. If the tenant hasn't been able to carry out its roof repairs as a result of the panels being in place, then that clearly could result in a dispute. So, what we've been recommending to our landlord clients is that they prepare partial schedules of condition prior to the installation works. So it's absolutely clear what state the affected section of the roof was in prior to installation, and that will help with questions over repair on lease expiry. We're finding it's often the case that roof repairs are required prior to the kit being installed anyway, so there's an added benefit to the landlord there of getting a partial schedule of condition prepared prior to the installation too. And then the final point from me is just to be aware that solar provisions are not normal lease clauses. So, where you're incorporating a solar schedule into either a deed of variation or a lease, it's not a standard lease clause, and therefore it could be deemed to form a personal contractual obligation between the original parties, which will not automatically transfer to a new landlord in the event of a sale or to the assignee of a tenant's interest under the lease. So we would always recommend incorporating wording into the drafting requiring that an undertaking is granted by the successors of either the landlord or the tenant's interests in the lease, just to ensure that those parties continue to be bound by the solar provisions of the agreement in the event of any sale or assignation. So I'll now pass back to Graham to consider matters from the tenant's perspective.
Thanks, Claire. So yeah, as Claire mentioned, I'm going to be looking at things here from the perspective of the tenant. And I'm going to look at it from two slightly different scenarios. Firstly, the things that the tenant needs to keep in mind if the landlord is the one who's installing the solar panels, just as Claire's been discussing there. And secondly, where the tenant is the one who's installing the solar panels themselves. There's a number of potential impacts on the tenant in either scenario, which might not be immediately obvious, but that the tenant needs to be aware of. So, where the landlord is installing, landlords may seek not only to install panels on the roof, but also equipment such as inverters within the property that's leased to the tenant. And this might include cabling connecting to the existing electricity wiring within the unit, which, like the roof, may be leased to and is therefore the responsibility of the tenant. The tenant will want to think about liability. What happens if somebody gets hurt or there's an issue or a fault? What happens if the circuits in the property get overloaded and cause damage or even a fire? The tenant will want to make sure they're protected and the landlord retains responsibility for the installation and for any damage or injury that's caused. Tenants will also need to consider if their insurance arrangements need to be updated. There's also the question of what happens if the installation of the panels directly or indirectly causes repair issues to the roof that would not otherwise have occurred. So, what if the installation has caused holes in the roof so that water leaks in during bad weather, which the tenant then needs to pay to remedy or causes disruption to the tenant's business? These would need to be excluded from tenants' liability under the lease, although it's quite important to note that proving something wouldn't have occurred but for the panel installation can be quite difficult, even if there is express exclusion in the drafting. Claire hadn't touched on this, but I'm just going to mention it briefly from a tenant's perspective. But where you are a tenant in a multi-let building where the roof is common, such as a shopping centre, tenants are less likely to be able to object to solar panels as their landlord's the one who's going to have control and responsibility for the common parts of the building. The tenant's main concern here is therefore the service charge. The tenant wants to make sure that the capital cost of the panel installation isn't paid by the tenants through the back door via the service charge, and that the costs of maintenance and renewal are either excluded or are going to be reasonable, especially if the electricity is going to be for the benefit of the development. All of these issues need to be carefully considered when negotiating a new lease or even extending an existing lease where a landlord is seeking to add green clauses into the lease. You also, from a tenant's perspective, want to be careful of any generic reserved rights which a landlord may seek to include with a view to allowing them to install solar panels in the future, as these generic provisions may leave the provision regarding everyone's rights and obligations and remedies against the other a little uncertain. Can I have the next slide, please? So on the other side of that, what if it's the tenant who's the one who's doing the installation? So let's start with the basics. If the tenant's the one installing the panels, the first question is, can they? The first thing to do is check the lease. most leases will restrict structural works or anything that involves a roof. So you're going to likely need landlord consent. Then there's a question of who actually has control of the roof. Is it part of the premises that's leased to the tenant, or is it common parts? If the tenant has control, then subject to approval from the landlord, the tenant should be able to proceed with the project. But what then? So the tenant will typically enter into an agreement with the solar operator for the installation and operation of the solar panels. Under this agreement, the tenant agrees to consume electricity generated by the panels before using grid electricity, and it's a way for them to lock in lower energy costs and to reduce their carbon footprint. The agreement is often referred to as a power purchase agreement, but it's actually structured as a sublease, which is usually of a slice of airspace just above the roof of the building, which is essentially the airspace in which the panels are located. And this gives the solar operator the rights to install and operate the panels and to run their plant and equipment through the building. The solar operator subtenant will also require access rights for maintenance and repair, and it's important to check at an early stage in the process whether there are sufficient rights already in the lease, which the tenant can then back to back with the subtenant. I think it's important to get these right, especially around access and maintenance and removal at the end of the term. In terms of repair, under the sublease structure, the tenant will usually be obliged to maintain the roof in good repair so as not to damage the solar equipment. But on the other side, the subtenant must keep the solar equipment in good repair and indemnify the tenant against any damage that might be caused to the property. The duration of a sublease is likely to match the duration of the lease itself, and at the end of the term, the equipment will generally be removed and any damage to the property will be rectified by the subtenant. In some instances, it might be possible for the parties to agree that ownership of the equipment will transfer to the tenant for a price, but this will generally be linked to the lifespan of the equipment and whether that's viable or not. There's usually no rent payable under these sublease arrangements because the installation costs are high, but the tenant will pay for the electricity generated and consumed on site from the solar equipment. And that's the way that the solar operator makes their money from this sort of setup. In relation to other documentation you might need when you're doing a tenant installation, the landlord will usually require that the tenant enters into a license for works. The tenant will also need to be mindful of their underlying lease obligations. For example, with an FRI lease, the tenant is usually responsible for keeping the roof in good repair. Adding solar panels might make this more difficult or costly. Because the roof is going to be covered in panels, access might be more difficult, and the landlord may also require specific contractors to be used for roof maintenance, which might also be more expensive. Maintenance, I think, is another big one. If the tenant is installing the panels, they'll be responsible, at least when facing the landlord, for keeping the panels in good working order. This might be part of their general repair obligation under the lease, or it might be dealt with separately in license for works. I think either way, it's quite important to be clear at the outset as to be who's responsible for what, especially if there's any damage to the roof or interference with any other equipment that might be up there. For a tenant installation, the landlord will also look for reliance on the loading and structural surveys that the tenant carries out. And these surveys confirm whether the capacity of power generation can be achieved from the planned installation, and also, quite importantly, whether the building can support the weight of the panels on the roof. We've seen that it's actually worth just offering the landlord reliance on these surveys up front, as the landlord's usually going to ask for this anyway, and it saves a little bit of negotiation down the line. So, in summary, the pros for the tenant of them carrying out an installation is it boosts their green credentials and it allows for cheaper power from a green source. The landlord is also going to appreciate the improvement to the EPC rating of the building. On the flip side, I'd say the cons are that the cost of entering into the various agreements with the solar operator can be quite high, and the tenant would also be responsible for meeting the landlord's professional fees, as with any application for consent. Can I get the next slide, please? Now, a slightly less obvious point is business rates. So in Scotland, the installation of solar panels can potentially affect the rateable value of a property under the non-domestic rates valuation rule modification Scotland regulations. If the panels are above a certain capacity, they can trigger what's called a relevant increase in value if other conditions are also met, and this includes potentially the installation of solar cells or solar panels. There are some rates reliefs available, and smaller installations might be exempt, but it's just something that tenants should factor in when assessing the financial impact of the project. So now I'm going to hand over to Adam and Jane to give their perspective on solar installation from a construction perspective.
Thank you. So our section covers just a brief look at some construction contractual issues that apply to solar installation and it should be borne in mind either when acting for a landlord, tenant or third party. And from a construction perspective, I'm told by engineers, including Adam, that the installation of solar panels in a building is relatively simple. Many companies now offer a full turnkey solution in relation to these works, and there are a whole range of procurement options available in the market to carry out the works depending on the exact scope and value. An EPC contract, which is an engineering, procure and construct contract, is a very popular choice. That's where the solar contractor may provide a one-stop shop of design, construction and at a cost, but very often ongoing O&M support. There is essentially one point of responsibility for design, construction and importantly, usually performance of the solar project is very much viewed as a turnkey solution. For clients who have got a number of assets across the UK on which they're looking to appoint a single or a few contractors to install panels on the whole portfolio, we have put in place bespoke framework agreements. Now that allows them to pre-agree terms and conditions of contract for all of these projects to be carried out and just populate some project specific details on a project by project basis within different call-off agreements. It's quite an efficient way to do it. Many construction contracts for solar projects are in a bespoke form or inspired or loosely inspired by industry standard forms, but that does mean that a detailed check generally needs to be carried out in each contract as no assumptions can be made without about the provisions and standard forms just applying. But it is also the case often that the work is conducted under a recognised form of industry standard contract. Now that might be FIDIC, NEC, or less commonly JCT or SBCC. So NEC and FIDIC industry forms are internationally recognised and they're typically used for projects with significant engineering elements. These standard forms are very often enhanced by special provisions or Z clauses in the case of NEC, and that's to ensure that they provide more protection to the employer under the contract than an unamended standard form, which are generally viewed as a bit more balanced towards or skewed towards contractors than what would be considered the market norm. So I think having a look at attendee list today, many people in the audience might be more familiar with standard build contracts for commercial development. These types of EPC contracts contain many similar provisions to those in standard build contracts, but they do take a slightly different approach to certain risks and obligations. And I'll just highlight some of the key features of these EPC contracts this morning. So these contracts typically provide for a maximum limitation period. For example, if governed by English law, it will be executed as a deed with a 12-year cut-off liability period, or sometimes even shorter. We have seen 5 or 6 years on many occasions. Amendments to the standard form will include a requirement on the contractor or any design subs to provide collateral warranties and letters of reliance to interested third parties. So that would include tenants, landlords or funders as appropriate. EPC contracts as standard will contain a requirement to maintain PI insurance cover, professional indemnity insurance, that responds to negligence in design services, which Adam will come on to look at shortly. Just on to the next slide, please. They will also tend to include a total financial cap on the contractor's liability. So the contractor will never be liable for more than the amount specified. Sometimes that's the relevant contract sum, sometimes for less, depending on the value of the project. And often there is a complete exclusion of consequential loss or perhaps a sub-cap on those types of losses. So again, slightly different position to a regular build contract. There will often be an obligation not to put the employer in breach of any third-party agreements, like a lease or a funding agreement. A contractor will often, rightly so, ask for a copy of the relevant lease or agreement prior to signature of the build contract just to ensure that the terms align. So construction work is inherently dangerous, especially working at height. Health and safety obligations and references to relevant legislation need to be included. They may be quite specific site working requirements if it's an operational site. Under the CDM regs, a client has got statutory duty to take reasonable steps to ensure that appointed persons have got the necessary skills, knowledge, experience, and organisational capability to conduct the work safely. Failure to ensure that's the case can result in criminal liability. We would say we are seeing that there are a lot of new entrants to this market at the moment who may not be particularly well established with a trading and performance history. So due diligence on these parties carrying out services and works is absolutely key. Manufacturer warranties relate to certain equipment which will need to be delivered. Now, Adam will come on to look at the detail around some typical products, but the technical pack attached to the contract will include details of what, if any, guarantees are required, i.e. what's to be given to the employer or the landlord, usually within the employer's requirements, which is one of the core technical docs. On to the next slide, please. Okay, so typically in these contracts, there is a concept of employers taking over. So that's the point at which the care and the responsibility of the works is taken over by the employer, should be akin to practical completion under a standard build contract. Taken over usually will not be considered to be complete until certain preconditions are achieved. For example, perhaps the contractor delivers copies of the manufacturer warranties and any other specific requirements. The list can really be quite long, as we've seen in some contracts. There will also likely be prescribed tests on completion, which the works must pass before taking over takes place. So is the system capable of generation and has been connected to the grid at the meter point? Are the works performing as expected for the point of takeover to occur? Usually a performance certificate is also issued. Now that's on expiry of the defects notification period, and that confirms all contractual obligations have been met. Again, it's important that you're clear on all deliverables required for this to happen. The contractor must have supplied all documentation required, must have completed all prescribed tests and addressed any identified defects in the defects period. Tests after completion will take place after takeover, so in the defects notification period, and they're carried out to ensure that the works function and they perform as expected long term. So if the tests are failed or output is not achieved, the contractor will be required to rectify the works to achieve performance requirements in respect of power generation at output capacity. And where these are not met, the employer can either seek general damages or, as is very common, specified performance-related damages might be set out and payable under the contract. Bespoke defects regime, just to mention that these are very often included in solar EPC projects, particularly where the nature of the works means that the serial defects can occur with multiple panels and they're not one-off incidents as such. So provisions are usually included which protect against systemic problems and will oblige the contractor to conduct a really thorough analysis of the root cause of the problem and submit a methodology for correction. And lastly, bespoke obligations often need to be included in these contracts regarding particular maintenance requirements, given the nature of the installations and their own specific requirements. I'll now pass on to Adam to look at some of the common defects which can occur for these types of works and means of recourse.
Thanks, Jane. In this part of the webinar, I'm going to draw upon my previous experience working as an engineer for a company that designed and installed solar systems to look at the risk of defects in solar works and some of the consequences thereof. I should note that this part is not intended to scare anyone, but is rather intended to highlight the importance of taking time to ensure that liability rests where it should. Defects in solar works can generally be distilled into three categories. These are design defects, workmanship defects, and product or manufacturing defects. I will look at these in turn. For design defects, from a purely engineering standpoint, as Jane has mentioned, solar is generally relatively simple. There are typically no moving parts. The electrical design is standardized, and the fixing systems used to anchor the panels to buildings are again largely standardized and well understood. Accordingly, most design defects will either be of a structural nature or electrical nature. In respect of the structure of a building, a solar panel array can act as a large sail, and in the worst case, rip the entire roof off a building. This has happened. Further, a solar array installed on a flat roof that could not be fixed or penetrated through will use ballast to keep the panels in place, such as breeze blocks or even sand. As you can imagine, putting too much weight on a flat roof can have dire consequences. And likewise, using too little ballast can result in panels being blown off in high winds, endangering both people and property. The chosen contractor must ensure that an adequate fixing system is used to attach the panels, and such a system must be suitable for the building and the roofing system which is present on the building. Negligence in this area could invalidate roofing system warranties, make maintenance more difficult, or cause significant physical damage, again, to people or property. If the viability of the investment is dependent on energy generation and the amount of energy generation, then the electrical output of the panels becomes an important consideration. Contractual revisions around performance can be critical, as Jane touched on. The design of the system, therefore, can make or break actual output in the real world, and negligence in this area could turn a good investment into a bad investment. As smaller contractors and consultants or new entrants to the market tend not to have assets to respond to a claim, anything that increases their likelihood of recovery in the event of design defects is of value. That could be to either a tenant or a landlord or a funder. Accordingly, at the very least, professional indemnity insurance should be maintained in a suitable sum and basis by all parties with design responsibility to respond to civil liability claims of professional negligence. External consultants engaged by the contractor, if it's more of a sort of turnkey basis, should be willing to provide letters of reliance or collateral warranties in favour of all interested parties to give further avenues for recovery. Alternatively, the person or the party procuring the works may choose to employ its own professional team with expectably vetted experience, insurance, and balance sheet strength, so that design of the system is under its control before the works are let to a contractor. Although this potentially is more expensive. Next slide, please. In terms of workmanship defects, it may be stating the very obvious, but the roof of a building is a very important part of the structure. And so poor workmanship has the potential to cause significant pain further down the line, whether through fire, through water ingress, or through making maintenance more difficult or dangerous in the future. Again, poor workmanship has the potential to injure both property and people. Poor workmanship may also vitiate roofing system warranties sustaining from the original development, which has the potential to cause significant losses further down the line. Normal legal liability for poor workmanship should sustain, either through limitation under English law or prescription under Scottish law, regardless as to whether an O&M package is purchased or not. Terms and conditions purport to exclude this liability entirely should always be rejected. A contractor should stand by its workmanship. Next slide, please. And then finally, on product or manufacturing defects, which is of particular importance with a solar installation, which my colleagues have touched on as well. A solar installation typically has 3 or 4 main pieces of equipment that are critical to its performance. And all come or should come with product guarantees. These are the panels themselves, which typically have a 25-year performance guarantee. The inverter, which converts DC power to AC power, typically a 10-year performance guarantee. And the fixing system, which varies. If battery storage is included as part of the system, such batteries will also come with roughly a 10-year performance guarantee. It should be the bare minimum that installers assign or otherwise register these product guarantees in the tenant's or landlord's name as appropriate. And this will likely be provided before under the relevant agreement for lease, or license for works. It will be a condition of these warranties that the equipment is installed by registered or competent installers in accordance with manufacturer's recommendations and are accordingly maintained in accordance with the manufacturer's recommendations. As such, it is vital, especially where energy generation is a key driver, because, for example, if an inverter fails, the panels are not going to generate anything. There is a maintenance agreement entered into with a competent party, which may or may not be the original contractor. with a term requiring that these warranties are not vitiated. This will give higher likelihood of legal recourse in the event that they are. And I'll now hand back to my colleague Graham, I believe, to wrap everything up. Thank you.
Thanks, Adam and Jane. Well, I think it's quite clear from what everyone's been talking about this morning that there's quite a lot to these solar projects, and that's certainly been reflected in some of the questions that have come in from everybody. So I'm just going to pick a couple of those just now for the panel. So Claire, this is maybe one for you. So should power purchase agreement and any landlord's works agreement be incorporated into the lease or into a deed of variation?
So it will really just depend on the circumstances in each case. It's generally easier for a tenant if everything is in the one place and in one document that you can register at the Books at Council in Session, where we register most of our documentation. I guess from the landlord's perspective, they'll just want to be sure that they don't have any plans to bundle up and perhaps sell the income stream from the solar kit to a third party, in which case it might be easier to have the power purchase agreement in a separate document. But generally speaking, to cut down on the number of documents is always a good thing. And if we can incorporate into schedules, then we'll certainly look to do that.
Perfect. We've got a couple of minutes left, so I'll just pick another question here from the list. This is maybe one for actually the whole of the panel here. How important is it to ensure that maintenance obligations under a solar product guarantee are complied with?
Thank you. I think I'll take that one. It's extremely important. It can invalidate the guarantee. We have had some real life examples of solar panels and actually other pieces of equipment on buildings too, where rejection of claims have been made on the basis the maintenance obligations haven't been adhered to. So I think where there are quite rigorous maintenance obligations or requirements, keeping a really good audit trail of those inspections, tests, etc., all things that have been carried out relative to the products should be there and available in the event of a defect or a claim. It's very handy to point to a log or a register where these regular checks have been made. We've actually seen that in relation to cladding as well as solar panels. So it's a general pattern, I would say. That emerges when defending claims.
Yeah, fantastic. Well, what we'll do is we'll wrap up the webinar there. But if anybody does have any other questions or they want to discuss anything that's been spoken about this morning, then please do feel free to get in touch with us. And all I would like to say now is just to thank everybody for joining us and enjoy the rest of your days. Thank you.
Thank you.